Good morning, everyone.
Good morning.
Good morning.
And on behalf of the entire team, I would like to welcome you all back at ABC Attorneys Learning Hour, where we give free legal education on various topics. I'd like to give a warm welcome to all our newcomers. Thank you for joining us today. My name is Hotan Abdi, and I'm the practice manager at ABC Attorneys. I'll be your moderator for today's webinar to discuss on virtual wills. Before we begin, however, I'd like to give a brief introduction for our newcomers. ABC Attorneys is a corporate and commercial law firm that specializes in specific area of focus being intellectual property. We're also a member of a newly formed legal intellectual property association named Amani IP. It's a group of 3 legal practices in East Africa that have merged together, and the idea behind this is to be able to have a single effective IP department that caters to the East African corporate market. We're also a member of the prestigious Taglo Group, which is an alliance of independent law firms with over 160 law firms situated in over 90 countries worldwide. Given the current COVID-19 global pandemic and its ramifications, we understand that some of you and your loved ones may be maintaining social distancing, while others may be ill or are currently subjected to quarantine. And all are wondering how he or she would be able to have their wills drawn or prepared via virtual means. This is where my colleagues will further elaborate on the legal spectrum and guide you through the process on the types of wills, how wills are prepared, and all the prerequisites required to complete a legally binding will. During the presentation, please feel free to address questions you may have via the chat box, and we shall attend to them respectively. You may also email us on info@abcattorneys.co.tz. And now, without taking much of your time, please let me introduce to you 2 of the speakers, of our speakers today, who will be educating us on wills and how to navigate them through virtual means. We have Mr. Sylvester Temu and Azadi Kalike. Sylvester, please kindly introduce yourself to our participants.
Good morning, everybody. I'm Sylvester Temu, a corporate and a commercial lawyer in ABC Attorneys. I'll be taking you through how does written wills been written.
Contesting advocate. Like Sylvester, I'll be running you through the concept of virtual wills and how to navigate them. Thank you.
Okay, I'll be starting by explaining how does virtual will writing works, the importance of protecting your family and asset. Okay. This presentation has been governed by laws, Probate and Administration of Estate Act, Indian Succession Act, and Quran. The key terms that will be used in this presentation are hereby defined. First, we need to understand what's the meaning of a will. A will has been defined under Section 2 of the Probate and Administration Act. It means a legal declaration of the intention of a testator with respect to his or her property, which he or she desired to be carried into effect after his death. Who is an attestator? Attestator is the person who has made a will and give his legacy. Who is an attestator giving a legacy to? A legacy of an attestator can be given to his heirs. Who are the heirs? Heirs are the person legally entitled to the property of the deceased. We also define who is a deceased. A deceased person is a person who has died. So this presentation will explain on two types of wills, oral will and written will. What is an oral will? An oral will is a will that has been delivered orally. A written will is a will that has been delivered in writing. So furthermore, we need to understand what's the advantage of having a will. One of the advantages of having a will is to clear uncertainty in relationship to who gets what in a relation to the deceased property. In this case, having a will clears uncertainty in the family. Everybody understands, or the testator divides who gets what on his property. Another thing is to ensure that the rightful heir benefits. Another important of having a will is to make sure that your legacy, your property, is being benefited to the person that you need. The other point is avoiding conflict in the society. Having a will reduces conflicts. Conflicts within family, within society, makes your property to be shared that you like. Also identifying the guardian of the deceased child. Sometimes an attestator, the one who's making a will, may have children who are under the age of majority. So in preparing a will, you cannot put them as the heirs. You only put a guardian who will give the heirs their property when they reach on the age of majority. Disadvantage of making a will. We understand a will is only take effect after death. So when a testator makes a will, it only take effect after his death. No person can access a will when the testator is still alive. The will can be ineffective with minor involved. A will that states or gives power to the heirs who are minor, it's a defective. So when an testator wants to make his will and he has children or heirs who are under the age of majority, he should select to have a guardian who will guide the property and their shares until they reach the age of majority. Requirement of a valid will. What makes a will to be valid? First, it's a testamentary capacity. This means the person making a will, the attestator, must be in a capacity of sound mind. Also, the will should state that he is willingly to share his property in a state of mind which is sound to his heirs. So the will should also clearly state the capacity of the one making it. Also, a valid will should have an intention of making a will. So an intention of making a will, so a testator has an intention that his property will be shifted or will be given to his heirs. So the will should have the intention of it being made. Another thing is a will should have witness. We'll see different wills as we see, we'll see different witnesses. There are witnesses who are 2 in writing a written will, and we'll see 4 of them in an oral will. So a will should be witnessed. The witness stay there to witness the capacity of the one making will. Was he or she in sound mind? Was he knowing what he was preparing? Does the property goes to the heirs? So a will should have attestation clause. Attestation clause is a clause where an attestator states that he wrote this on his own mind and the property will be shifted to his guardians. And also this attestation clause, also witness will attest and also advocate will be there to attest that what was being written is what the attestator wants. Formality of a will. There are different formalities of preparing a will. We can see one of the formalities a will should be signed at each page by the attestator himself and the two witnesses. Those are among the formalities of a will. Another formality of a will must state that it deletes other will that has been made before, and that one will be the genuine one for the attestator. So we go forward with things to consider when writing will includes a person should be on sound mind. And sound mind means a person should be on capacity, knowing what he or she is writing. A person being of unsound mind makes a will to be invalid. In this case, when a person is ill, intoxicated, with mental issues, he cannot be capable of writing a will. Another thing is should be at the age of majority. A person that is being allowed by the law to make a will must be above the age of 18, not a minor. The will should bequeath their own property. If, for example, I, Sylvester, have property, I should mention the property that I am owning, but not bequeathing the property that Hazard has. The only effect of a will, a person can bequeath only his own property. There should be two witnesses, one be a relative, another being another person. So in making a will valid or in writing a written will, there should be witness that witness the attestator when he's signing the will in order to be taken to custody. State of the maker. Also, the will should state who is the maker. The maker, in another sense, is the attestator himself, the one who is making the will. Also, the will should appoint the executor of the estate. In this case, having a will needs the attestator to state who will execute his estate when he is not on this earth, when he's died. For example, I can say maybe an executor of my will be ABC attorneys. When I'm gone or when I'm dead, ABC attorney will take a point of executing all my estate properties. Another thing, a list of properties to be executed. A will should mention a list of property that will be executed by the executor. More than that, a list of beneficiary of the disease. A will should mention all the beneficiaries. My son, my relatives, if I'm willing to distribute my property to all my sons, my relatives, there should be listed on the will in order to make the will clear. Distribute the property. The distribution of the property to the heirs must be explained in the will. So an executor will execute what has been stated by the attestator in his will. May state where to be buried. Sometimes people benefit or people like to state where they will be buried when they are dead. As an attestator, or for example, as I, Sylvester, I will choose maybe to be buried in Dar es Salaam because Moshi is too far. So the wishes of the attestator must be executed by the executor on what he has written on his will. Signature of the maker and witness and commissioner for oath. In a will, there should be a signature of the maker and also an oath of the commissioner who is an advocate. I hope everybody sees the polls. There's a question, how you ever consider writing a will. I think you can choose yes or no. Then our moderator will provide the results and we'll share them with you. Going through.
Yes, thank you, Sylvester. I'm waiting for the poll results.
Yeah.
We'll share. Or should we proceed with Azad? While
Yeah,
we're waiting. Okay.
I can say we have the results. Have you ever considered writing a will? I can say yes, 75% have considered writing a will and 25% have not considered writing a will. So it seems that most of our participants in this webinar have the understanding of having a will as their legacy. That shows a great thing in their life. So the other thing by continue is a place where we can store will. After the will has been drafted and been witnessed by the witness, has been signed by the testator, have been stamped by the Commissioner of Oath, there are 5 places where you can store a will. First, according to the law, to the High Court of Tanzania, you can go and register your will there to be stored. The other thing, you can register for the land registry as a document. You can go register it as a document and be kept there safety. The other place is RITA. You can go and register it into RITA. Also, you can go and make a deposit of your will at banks, and also you can go and deposit at your attorney's office. So this attorney's office is, for example, ABC. We have drafted a will that you want. We are the Commissioner of Oath. We took through all the procedure of having a will. So it's important to have a copy on our office. As when you passed away, when you pass away, we'll be there saying what your will has been written. From here, I think the moderator will continue for another panelist to continue. If there's question popped up, we can answer them, or we can answer them at finishing the presentation. Then take through, please.
Thank you, Sylvester. And now we shall begin with Azad. Azad, please take over.
Thank you, Helen. I think there are 2 types of wills, as it was explained earlier. There is a written will and oral will. However, there are many varieties. Now, we will not go into the varieties, but we'll try to explain the core types, which are written and oral. Written has been explained before, and now I'm going to go for oral. These are wills that are passed by word of mouth without writing anything down, and they're made in presence of not less than 4 witnesses, and 2 of whom must be relatives of the testator. Oral wills are common and customary in the customary regime of probate and estate administration. I've not seen it commonly in other regimes. And further, if the witnesses die before the testator, another will must be made. And if the number of surviving witnesses is reduced to 2, the will is cancelled or considered null, and this estate is administered as if the deceased died intestate. You know, it's not just that if I leave behind a will, it will be executed as soon as I die. I have to petition to various or respective courts for one to be granted probate papers. And in petitioning for oral wills, one is required to produce an affidavit of the person with personal knowledge of the content of the will, and also consent of the persons if the deceased would have died intestate and would be entitled to property. Now, thing is, as you've seen, the formality in petitioning is quite absurd. Now, if I want people to benefit from my property, it means that's my will, that's my willing. And now, if someone has to consent to my wishes, then you know there is going to be a problem, and we have seen it in society. So the best way would be to write a will. Avoid making a will unless circumstances call for it. Now, there is something we have not explained all through, but I think it's important for us to go through it. The concept of the 4 regimes that govern probate. Why do I have to go through these regimes? Because every will should be consistent with the regimes. There are 4 regimes which are the statutory regime, the Hindu regime, customary regime, and the Islamic regime. All these regimes have their ways of writing wills. But the most significant and the most challenging the customary and the customary and the Islamic will. In regards to customary, most of these wills are done orally. They're done orally, considering the people that tend to use all wills. It's because most people that are recruits and stuff of the kind. But with regards to Islamic, it has its peculiar laws, which include that no one can bequeath more than 1/3 of his property, and the rest will be bequeathed according to the Quran. Now, when writing a will, I explain these regimes because when writing a will, we are going to consider numerous factors. These factors include the way of life of the deceased. Now, if it happens that a will is written contrary to your way of life, then we are going to contest your way of life and say, no, this one was a Muslim, or this one, this will is Islamic, but this guy was not a Muslim, or he was a Muslim, but he was not living the according to the Islamic way. So we are going to contest, and either you might have left a will, but that is inconsistent with your way of life, and it will be tossed away, or that is inconsistent with the rules or guidelines of what you intended to write, and it will be tossed away in court. So we'll have to skip your wishes and write in whatever way we want. And further, there is something that we also tend to ignore, that there are co-beneficiaries in writing a will, and there is no way you're going to lock them out. Say I have my children, and here I'm talking about statutory wills, because in regards to Islamic and customary, the heirs are mostly mentioned and stated categorically. For example, in customary wills, the Local Customary Declarations Act says there will be layers and of heirs. So there will be the first layer, the second layer, and third layer, and the fourth layer. So property will be divided according to these layers. And every other custom has its way of dividing this property, but according to these tiers and layers. In regards to Islamic, we first consider children, the male children, then the female. The male gets 2/3, the female gets 1/3. Then we go to the wife, who gets an 1/8. Then the parents get a 1/5. Then if property still remains, we will consider the other relatives, or in absence of the Quranic or Quranic beneficiaries, co-Quranic beneficiaries. Now, in regards to statutory law, you cannot lock out your beneficiaries. However, there are peculiar circumstances that call for action. For instance, I don't bequeath nothing to my children because, one, maybe they try to kill me, or they are the cause for my death. But mostly they try to kill me. So that means legally I'm allowed to abstain from giving them or bequeathing anything to them, and they will contest this in court, but they will not get through. And the other reason is, say it's me writing a will and my children try to sleep with my wife, and that's reason for me not bequeathing property to them. Now, having said that, I would like to grace the idea that we're trying to introduce, the idea of virtual wills. With virtual wills, I'll go through how it's done. A question has popped up here that, do you think it's a wise idea to write a will? I think the participants will go through the poll and give their answers, then we'll address it as the answers come through. But in the meantime, we'll proceed with what is going to be addressed in virtual wills. We'll address the idea of how do we write how do we write will virtually, and is it legally accepted? And I'll also write why should we consider doing wills virtually. Now, starting with the first part where I said, what do we mean and how are we going to conduct virtual wills? Virtual wills are wills that are conducted when one party is at a remote area. In this in regards to our presentation, the other party is an advocate. Now, the processes. The first procedure will be setting up a video call. It's either by way of Zoom, as we're doing now, or Skype, or any other virtual means of communications whereby we will collect and receive instructions from the client or prospective client and tailor the client's needs, tailor the client's instructions to cater for his specific needs. Then after creating this, after tailoring this, these instructions, we'll create a draft which will be sent to the client. For review and input. As we know, we're just humans. It's very difficult and very rare that you give instructions, they come through as you expected. So we are going to print it and send it to you. We're going to send it to you by various carriers, including DHL and any other deliveries. Upon receipt of the will or draft will for that case, the testator will read the will, and as it's required by the law that there should be 2 witnesses, and we recommend at a time of reading this will and attesting to the will that the witnesses be present with the testator. And we at the firm, ABC Attorneys, will record the whole event, the event of attestation of the witness, of the testator, and attestation of the witnesses, and when they sign their verifications. Why is this important? Because the logic of the law of calling for a witness is to ascertain whether the person attesting the will did so under no influence, willingly, this means, and they were of sound mind. You know, sometimes someone might be of unsound mind, and you know, they are forced, they are pushed to write a will. So the witnesses in this regard will witness that this guy, Sylvester Temu, when signing this will, he was of sound mind. And you will also attest to this, that I am of unsound mind, of majority age, and free of will, I bequeath my property to blah, blah, blah. And the witnesses will also attest to that you are of sound mind and of free will. Then they will sign verifications, and the will be forwarded back to the firm, ABC Attorneys, and we'll look into it. Then we'll also play the part of a commission of oath and witness your will. Then after doing so, we'll register your will with RITA and retain a copy. And you might be asking or questioning, why should you retain a copy? As we know, RITA and the other registries that have been explained by my co-panelists earlier are government agencies. And as you know, it requires due process and procedure for one to be able to attain documents from a government agency. But with ABC Attorneys, this is your attorney, this is your firm. So at any point where you have passed, the staff at ABC Attorneys or any firm of your choice will be able to bring you your will for your beneficiaries to benefit on spot, because some of us die leaving behind beneficiaries or dependents that require our presence and our assistance so often and on spot. For instance, I leave behind children that go to school. This means if it's school time, a fee has to be paid, and if a fee is not paid, then it's going to be a lot of problem. So storing your will to your attorney makes it easier for your will to be accessible as soon as possible and as soon as it's needed. Some of us have businesses, and businesses require our funds for them to function properly. So with storing your will to your attorney, you will not have to go through due process, and your will be found on spot, and everything will be done through easily. Now, why should you? Why a virtual will? You know, after all these years of going through normal processes of writing a will, why do we bring to you the idea of virtual will? The idea is, you see, tough times call for tough measures. And part of these tough measures in regards to wills is considering digital platforms. And as you've seen, even the judiciary of our beloved country has started considering shifting its legal practice and procedures to fit digital requirements. And in regards to wills, we saw fit to take this initiative. Now, why should one conduct a virtual will or consider virtual will? The aim is to assist those in social distancing but have no access to face-to-face meetings with lawyers. You see, these times, COVID-stricken times, require us to keep remoteness in regards to physical meetings. This is to say social distancing, avoid unnecessary physical meetings. So we assist you in preserving this, and also those in foreign jurisdictions and have properties in Tanzania, actually specifically Tanzanians, and it's not limited to Tanzanians, but mostly Tanzanians in foreign jurisdictions, and they cannot see an attorney to write them a will or execute a will for them. So we seek to close this gap because this person cannot come to Tanzania to execute or draft their will. So through this virtual will process, we'll be able to ascertain and draft and execute their will. And also people in hospitals with limited access to legal assistance. As we have seen, the COVID pandemic has taught us one thing. We grace this earth, and truth be told, we don't know when we're going to leave. And sometimes the blow could just come abruptly without even expecting it. We have seen people lie dead in some places of the world. So this is the lesson. And for people in hospitals who are in critical conditions, but not critical in the sense that they cannot draft a will. Critical in the sense that they can still draft a will and they are of sound mind. We give them access to wills by conducting virtual wills. And those that are busy to meet with lawyers, but wish to have a will in place. You see, technology has one thing, and that thing is it saves time. It minimizes the use of your time. And through virtual wills, we offer you extra time for your other activities. Now, should you need assistance, our experts at ABC Attorneys, I see another question has popped up. Do you have a will? For me, I have one. It does not have a lot in it, but it's mine. I mean, it stands as far as I'm concerned. Now, going forward, should you need a will, our experts at ABC Attorneys maintain wills. They write them, and we do future planning services and advise clients so as to provide comfort and mentality to achieve even more by understanding key things in life and working harder to build a nation that we love, knowing that we and our beloved ones are protected. What we give you here is you don't have to work while bothering yourself that what if I die today? How is my property going to be divided? And our main objective is to support every client, their family, and their businesses whenever they need us. Now, as you're waiting for the poll of this, the results of this poll, which I'm going to address together with the last poll, and what I've been trying to address with my co-panelists is let's keep our property safe and our families protected. It's important to talk to a lawyer to assist you because we have this thinking that I can do it. Due process is written everywhere, but there are technicalities, and to get rid of them, it's important that a lawyer assist you, a lawyer of your choice, an attorney of your choice. And remember, it's possible to do so virtually. And not only wills, we call for involvement in the legal world where even contracts people should take instructions. It's important to take instructions by virtual means. It's important to do so by virtual means, since it saves time. It saves locomotion. You see, locomoting in a city like Dar es Salaam might take you 4 hours. So virtual wheels, we save you these 4 hours for you to do stuff. Now, a poll popped up. Do you have a will? Most of us don't have wills. It's not a bad thing. We are Tanzanians and Africans, and we have beliefs that writing a will is one way of predicting your death. But I tell you, after all the importances that my co-panelists brought forward, I think it's very important and very crucial that we have wills. We have seen societies, not societies, actually our societies that have raised us, having conflicts and relationships going sour beyond even repair because of property of the deceased. Now, having said that, I'd like to proceed with the next slide. Sylvester, please, could you move?
Okay, Hazard.
Yeah.
After I have seen the question that have been popped up, someone asked, how can a beneficiary be a witness?
Actually, okay.
Yes.
Actually, the law is specifically clear and categorically states this, that a beneficiary cannot become a witness. It's common sense. This will be like colluding. I'm the beneficiary, then I'm the witness. What am I witnessing? That I was given this property? No. So witness should be someone who is not a beneficiary, and it's not necessary that the administrator is present as a witness. It's not, because I've seen that question too.
Additional from that,
yeah.
A beneficiary is the one who benefits the property of an attestator. Being a witness contradicts the main aim of
I see. Hello, Sylvester. Is it internet problem?
Hi, so Azad,
Yes.
there is a question that had popped up here.
Yeah.
All of them, if we can address. There is one from Mr. Joseph Chiombola.
Yes.
He was asking on what is the effect if the will is not registered with RITA? Is it mandatory for the administrator to be present during the signing of the will? How would you address that, please?
I addressed the issue of an administrator being present. The administrator should not necessarily be present because sometimes these people are remote. And I think he used the word administrator. An administrator is the person that is going to petition, not necessarily should not necessarily be present. And the issue of is it a mandatory requirement to register the will with RITA? It's not a mandatory requirement, but since RITA is the agency that has been given full mandate with storing and recording wills, we think it's important that wills are registered there. But it's your choice, it's your call, because you could just keep it at your attorney's office and it will have full legal effect as much as the will that is registered with RITA. You could keep it at your bank, and it will have full legal effect. You could keep it at any registry of the High Court and it will still have the same legal effect as the will that is written with RITA. I think I addressed that one. Yes.
I believe so. And this, I would address it to Sylvester.
Yeah.
From Mr. Frederick Makidad. He's asking, what can I do when the will mentioned 2 executors and one of the executor refused to act according to the will? Sylvester, can you hear?
I think Sylvester's internet is a little bit problematic, but I could address that one too. Uh, in circumstances where you've mentioned two executors,
Yes.
and one of the executors refuses to act accordingly to the will, thing is, I have left my will in place, and an executor should not necessarily be two. It's only one. So if one executor does not act, the remaining executor will have to act. And I have, the thing with wills is, in regards to executors, is I mention an executor at a time. When I mention 2 or 3 executors, they will work, or each one will work in their own capacity in absence of the one that is written prior. So I'll have the first executor, second executor, and third executor. The second executor will only be in place if the first executor is not around, or due to circumstances has died, or stuff like that, or has recused himself. And also, if it happens that all of the executors don't want to act accordingly, there is a due process for that. I think you have to petition to set them aside. You first call them to court for them to state why they don't want to act accordingly. Then if they don't appear, it's for non-appearance, then another person is appointed as an executor. But that is a discussion for another day. I believe I have partially answered your question, but for more information, you could contact ABC attorneys through our email that is displayed in the comment section for more information. Thank you. My sister Sylvester is back. Yeah.
Yes, I've been having a network problem. So right now I think I'm good.
Can you hear me?
Yeah, I can hear you, Oren.
Okay, so there is another question here from Miss Imani Hatibu.
Yes.
The virtual will targets people in the urban areas who have access to technology. What other measures can be ascertained to support the people in rural areas? Perhaps you need to also explain on the what was
Okay.
yeah.
As one of the employees at ABC Attorneys, we have a project of providing legal service or legal aid to different places, to narrow places that they don't have technology. It's one of our target to make sure that we give back to the society. So in our project, we'll be visiting the people who are in rural areas. We'll advise them on how to make a will, because they do not have access of technology like having a meeting in Zoom. So we'll reach them in our project by giving back the society. So in that case, we'll make sure that the people who are in rural areas get this knowledge and understand the importance of having a will, and also get a chance for us to make them the will when we are still continuing the project moving around rural areas. I think I've answered the question.
Yes, thank you. And there is a follow-up question.
Yes.
From the same participant, Ms. Hatibu. What are the best ways to convince someone to write a will in Africa? It's like you're wishing someone death. As you can see from the poll results, most of us haven't yet drawn our wills up. So I'm assuming it's in line with the poll results. So
It's an advice. We advise the society to have a will, because everybody wants to leave a legacy in this world. So having a will, knowing what property that you have should go to the right people that you want, it's a legacy. So if you want to die with a legacy, we encourage you to have a will. And also, if you want to avoid your family to have conflict of your property that you own right now, make them safety. Also uplift love in your family by having a will, in order to avoid conflict between relative and relative, children and children, wife and other members of the family. Love your family, make a will to protect them, and make a will to leave your legacy in the society. I
Thank
think
you
I've
so much, sir. I believe so. So this question is from Mr. Godfrey Mwakipesile to Azad.
Yeah.
So he's asking, any legal standard of sharing properties to beneficiaries?
Any legal standard, the question is a bit wide open, but I'll say that there are legal standards. The property has to be yours, it has to be legal. You could not bequeath, say, an illegal property, maybe a farm that has bangi. That's not possible. Or you bequeath something that is not something that you don't own, or in case of land, say you bequeath land that you own jointly with another person, because as we know, in regards to land, if it's a joint property, when one dies, the other survives. For survivorship, the property passes to the remaining party. So these are things that you could consider. But the considerations are scattered all over the law in regards to shares. Shares have their limitations in regards to being passed. They can be passed, but they have their limitations. Land has its limitations, and they're in various statutes. So that's why we say it's important for one to for this process to be done by an attorney, because they have all these statutes at their disposal, and they have knowledge of these statutes and procedures for various properties. I think partially answered this question, but if there are still there's still more to qualify, I think it's important if he poses his question through the website that has been displayed. Thank you.
Thank you, Azad. So we have a participant, Mr. Godfrey Mwakipesile, who would like to interact live right now.
Yes.
Hello, Mr. Mwakipesile.
Welcome, Mr. Mwakipesile.
I think your mic has been unmuted. Can you hear us?
Hello, Mr. Godfrey.
I think maybe there's internet interruption to Mr. Kipesile's side. Can we continue with other question, if any? I have seen a question, a person asking, Mr. Kipesile is on.
Hello?
Father, do you have another question? Other, you are muted. I can't hear you.
Hello?
Yes, now I can hear you, Other.
Okay. I thought I heard Mr. Mwakipesile online, so I was giving him the chance. So we have another question. This one is the last one.
Okay.
Okay, this is from Ara. What about those living under presumption of marriage? Are they entitled to inherit? And if yes, what are the laws? What laws are supporting this? Thank you. meaning the will. I hope you
Okay.
understood.
Yes, I understood that if a person is living under presumption of marriage, is she entitled to have a cut from the attestator? Let me just be clear. A will, it's an intention of an attestator on how his property can be divided to his heirs. Whether you are under presumption of marriage, whether you are a relative, if the attestator is intended his property to be given to his heirs who are in a presumption of marriage, then you get your cut as the will states, because the will reflects the intention of the one preparing it, who is an attestator. So an attestator will list the list of the beneficiary of his or her property. If you're on the list of the beneficiary, then you'll get what an attestator has give it to you. I think I have answered that question. Odin?
Thank you, Sylvester. Another question again from
Sorry,
Ara.
sorry, Odin. May I interrupt a little bit? In regards to she's posed the question of people living under presumption of marriage. Like I said earlier, in these circumstances, we have to go through various laws. But if I leave behind my will and the person that I'm living with under the presumption of marriage has not been included, then it is for them to petition. So now, to avoid these circumstances, it's important to include these people and consider these people in writing wills. But they can petition and establish that there was marriage between you guys, the presumption of marriage. Then maybe she could win. But you know, as we've put it earlier, that our traditions, we tend to give the dead a lot of respect, and in most cases, the deceased, even though not present, their wishes go through. So it's important to put these people and their children and they will to avoid the suffering that they'll go through after we depart this earth, most especially if these people are our dependents. And further, I'd like to take on Ara on a question here that she says she understands that according to Islamic law, it does not recognize legitimate, no, it's illegitimate children, I think she's supposed to say. So how are these children going to benefit from their parents' properties? The issue here is not just Islamic law. Actually, illegitimate children are disadvantaged even under statutory law. So expecting statutory law, it's not given that you're not restricted, that you could give this to this at a certain percentage. But in Islamic law, it is restricted, and you're only given one third. So I think it would be smart if you have any illegitimate children, any illegitimate beneficiaries, beneficiaries that are not Quranic heirs, your friends, your concubines. I don't advise you people to have concubines, but if you have them and you want them to benefit, you include them in the one third that you're allowed, according to the Quran, to give to other people. And having said that, I think I've partially answered Ms. Ara, and I'll get some question out the way before I hand back to the moderator. What's the difference between animus testandi and mental capacity? Animus testandi is my willingness to make a will, but mental capacity falls under testamentary capacity. The capacity of one to make a will, like the capacity of one to enter into a contract. A will is a contract of some sort, because except that there is no consideration, there is no someone giving me money at the other end. But a will is the capacity of one entering it will kindly looks like the one of the person entering contract. So the difference is one is intention, the other is your capacity to actually make a will. If you're of unsound mind, you cannot make a will. If you're of minority age, you cannot make a will. If you're bankrupt, you cannot make a will in regards to the property that, the bankrupted property. So I think I've answered that too. Ms. Odin, may you take the floor? Thank you.
Thank you, Azad, Sylvester. So from our participants, I believe we have answered most of, if not all, the questions. We welcome anyone with any further questions. But there is one, I believe, from Joseph Chiombola. And there was one with regards to security. Just a moment. Yeah, how can we? Sylvester?
Okay. Mr. Joseph has asked what are the necessary security features for verification or authentication. In this case, when making a will, a testator is being compiled to sign, and also he can put his thumbprint on the will as a one of verification that he was the one signing the will. Also, the witness can sign and put their thumbprints on that document. That leaves no more question when an advocate or a person or a executor, when we will be reading the will to the family after the testator is dead, they will prove that he has signed and put his thumbprints on the document. I think I've answered him.
Yes, thank you.
Addition to that, Odhan,
Yes.
this presentation does not empower people to stay at home. We encourage people to still work, but to take precaution of the Ministry of Health. Have your mask, have your hand sanitizer, stay away from crowds. So we encourage people to take care of themselves. If you are at the hospital and you want to have a will, you can just contact us at info.abc.co.tz. Then you can continue from there.
Yes, we have another participant. She has raised her hand. We'll try and unmute her.
Okay.
Hi, I raised my hand for a long time. Thank you for letting me speak. I just wanted to ask, although I think Sylvester has answered the question partially, but I just wanted to know, like, when a will is out, how do you detect that it is the will that was left by the person, the antestator? You know, like, what are the signs that will tell you that this is the actual will left by the deceased? Thank you.
Okay, when the will is out, first of all, it will have the attestator signature. So the members of the family, maybe a testator has a wife, understand is the signature of his or her husband. So she'll be the one to prove that that is his signature. Also, if you remember, I said there should be two witnesses. In that case, when the attestator is dead, the witnesses will be the person to prove that their attestator is the one who signed the will, and it was prepared according to his will, and he was in a capacity of making a will. In that case, it will reduce conflict to the family and to the one who wishes to say that the attestator was not the one who made the will. Have I answered you?
Apart from that, there isn't any other way that you can prove that this will was made by the deceased, apart from the signature and the wife going through the signature and the two witnesses. That's all.
Also, as a commissioner of oath, as our firm or as an advocate, will be there as another witness that we witnessed that the will was made by the attestator and is witnessed by the two witnesses. As we have said that having a visual technology of preparing a will, we'll have a record of the videos that were going on when the will was prepared and where the signature was being made, and to its finality until it was registered. So those videos will be shared to the family at the time that the will be produced, if it is under our custody.
All right, thank you very much.
And thank you, Imani Hatibu. Now, I think we'll take the hello, Sylvester.
I can hear you. I can hear you, Olin.
One more question addressed to you from Law Online.
Yes.
What is the
Okay.
position of a child from Law Online?
Oh, his question is it's a little bit wider to explain here in this webinar. I think we will answer him. He should send the question via our info, because it needs to have a larger opinion to state the procedures and how the children outside the marriage can benefit, or the position of the will.
Also, may I addressed this earlier, but there is something that has been left out, that the law of the child has been amended to include specifically children out of wedlock and to identify them as children, because we in Swahili have a saying that mwana haramu harithi. This is a very common saying and has been adopted in probate administration of estate law. But now, even after the change of an amendment of the Law of the Child Act, the law has been quiet and has gone quiet in amending the Probate and Administration of Estate Act, because that's the mother law and that's the director of all probate laws. So now all other illegitimate children have been left with only an avenue to contest this, and to contest if they only contest if they are aware of probate proceedings. If they're not, then that's it for them. So in our advice, even with the change of the law, it's important that you consider these children when planning your estate prior. And also, even after the change of the law, there are, for instance, customary regime of probate and Islamic law. Still, there is a state of confusion in quagmire in regards to illegitimate children. So I think the law has been amended, but amendments should be addressed in the Probate Administration Act to make sure that even the probate, specifically the Probate Administration Act, has been changed and so as to meet the purpose of the amendment in the Law of the Child Act. Because if it's only the Law of the Child Act and amended, then the amendment remains hanging. And I'm not saying it has no effect; it has the effect, but remote effect. So thank you.
Thank you, Azad.
Yes.
Sylvester, do you have anything else to add on?
I will just thank everybody who has joined our presentation today. I encourage them to leave their legacy to the family and the society. Have your will in order to avoid conflict and to encourage love in your society and your family. Thank you, everybody.
Hold on, before we leave, Mwakipesile has been putting a mutiny. He wants to speak. I see through the comment sections, he's been coming back and forth. So maybe, I don't know if it's possible, he gets a chance to speak and address queries.
Okay, we can give him an extra added 5 minutes. Let's try and unmute him.
Mwakipesile is speaking, but we can't hear. I think there's a problem on his side. Makipesile, we do not hear. We can just see your lips moving, but we cannot hear you.
Okay, this is unfortunate, but we have tried, but we cannot hear you. It could be.
I think he should plug his earphones and try to speak directly to his phone.
Hello?
Hello, how about that?
Hello?
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 Hello, we hear you now, we hear you.
You can hear me now, eh?
Yes.
All right. Thank you. Hello?
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 We hear you, we hear
You
you.
hear me now?
Yeah.
Yes. Yeah, my question is very simple. I'm trying to ask, for the case of witness, you see the number, even the statistic, it shows that most of the people, they're not willing to write a will. And my problem or my take is announcing a case of the witnesses, the one which we are picking as the witness during the writing of the will. How are we trying to analyze them? Are they able to keep the secret that they cannot share to the beneficiary? And what it will happen if one of the witness discloses the fact that has been written on the will before even the occurrence of the death? And this one is one of the things which give fears to most of the people within the society, because they are not very much sure that if these witness, they can keep the secret, assuming I have 4 children and one have disclosed maybe 50% of my share, and one of my witnesses discloses the fact to one of the beneficiaries. This one may cause a very big conflict within the society. So I don't know what's the law, the stand of the law in case of these witnesses, they discloses the fact that has been written on the will. That I want to know, so that we can at least even remove fears within the society.
Thank you, Mr. Makipesile. Before Sylvester and Azad would revert on that, we have another colleague here, Winnie, who has raised a hand. Perhaps she can also assist.
Can you hear me?
Winnie, welcome on board. Did you get to hear Mr. Makipesile's question?
Yes, I have, and I believe it's a concern of many.
Okay.
Yes, so many people are confused of whether to make a will or not, and are afraid actually about the contents of a will coming out to the public, or who witnesses or the part of the attestators while attestating the wills. Actually, the law does not allow the disclosing of the contents of a will. What I'm trying to say is the witnesses are not attestating to what the testator has written in a will. They're actually not even supposed to know what the testator is actually writing. It's actually top secret. Why? The law knows, or the legislature knew, that if the contents of the will were let out to the public, it would cause confusion, or sometimes even the death of the testator before even the will is let out to the public. So what the attestators, the witnesses, are signing to is the fact that they witnessed the testator writing the will or making the will, signing on the will, and that he was in the right capacity or in the right mind to prepare such will. So they are not attestating to the contents of the will. They actually not supposed to know the contents of the will. At least the relationship between the testator, the person who's making the will, and their attorneys, for example, us, because the relationship is supposed to be built on trust and very highly confidential. So a person's attorney or an advocate could, because the testator would want to share his insights. How is he supposed to distribute or bequeath his estate and all that? So the attorney may know the ins or the ins and outs content of the will, and he will be directly involved in preparing such will, but the witnesses, that is not the case. They are not privileged to know the secret or the content of the will that a testator is making. So to rule out all the worries, and that includes everybody else who was afraid maybe to prepare a will because of that, a witness has no right of knowing what you're writing. He only has the right to attest that you were the one preparing the will and you were in your right mind and you are actually the one who signed and you are not coerced in preparing the will. So I hope I've somehow answered your question, Mr. Mwakipesile.
I can see Mr. Mwakipesile is nodding. That shows that the answer that you have given is right on his side.
Okay, so we have another poll result. So it's good to know that everyone now thinks it's a great idea. We have 100% for us to draw up our wills. Mr. Mwakipesile, if you are speaking, we cannot hear you though. But we hope Winnie's response did clear the questions and doubts you had, or clarified rather. Okay, if there is nothing to be added from my colleagues, Sylvester Azad, with this.
We just say thank you for your time. If you wanna have a will, you're welcome at IBC attorneys. We'll be there for your service as your attorneys and your advocate, having your legacy well prepared for your family and for your society. Thank you.
Thank you. And with this, we at ABC Attorneys, thank you all for joining us on today's webinar, and we hope that you're able to obtain at least 1 or 2 points relating to wills. Please feel free to contact us should you have any further questions to the email address provided, info@abcattorneys.co.tz. And for those who wish to obtain the slides, please kindly send us your email address and we shall share the same. Please stay safe, and wishing you all a great weekend. Ramadan Kareem to my Muslim brothers and sisters. Thank you all. Bye.
Bye. It was nice
Goodbye.
seeing you.
Thank you.
Safi sana. Naomba namba zenu za simu. Namba za simu. Namba za simu.
Tumeona email yako, tutakutumia bosi.
Okay.